Welcome. Today we're discussing challenging owners and some best practices with an experienced lawyer. Welcome, Phil.
Hi there.
Phil, you represent Citadel Law. Can you tell us a bit more?
Yeah, so we are a firm that started in 2018. We do almost exclusively strata law and things related, so often some landlord-tenant stuff, for example. But in that context, we, believe me, come up with all sorts of different types of litigation, just happens to occur within a strata corporation. So very diverse,
Looking
even if
forward
it's
to getting
narrow.
into this today. I know we had originally planned to do this alongside a property manager, but we'll come back and revisit it from their perspective in the future. Let's dive right in, shall we?
Excellent. Okay. Well, thanks for joining in with us, ladies and gentlemen. We're going to talk about a few things today, but you see here on my agenda, we could talk about many, many, many things. And so please do, if you have questions that come up from what I am going to say, but it's not on point per se, but it's making you think about a problem you particularly have, please just put it in the chat and Thomas and I can deal with it, because I'm happy to jump around, because as you see, the types of problem owners or residents, because they could be just tenants, of course, or occupants, which is a whole other world. There are many, many topics that we could cover. But what we're going to try and talk about is the processes that council members have to follow, hoarders, and the dealing with bullies. That's what we're going to try and get through today, and then we'll just see how far we get. But please do just jump in with your questions. All right.
So let's start with some bullies.
Right, exactly. So be very clear in your own mind. These are very much people like you had in high school who would bully some people or another. And you always wonder to yourself in school, why are there school bullies? And probably much the same as in school. You know, the bully comes from the troubled home. They've had a trauma of some sort. They may have specific mental illnesses, like you see there, obsessive compulsive disorder, um, or there, as I mentioned, that various traumas from drug and alcohol abuse of parents and those kind of things, or and then when we get into the strata situation, drug and alcohol or psychiatric problems within the people living there themselves. This creates a lot of tension, because people ultimately end up being very, very antisocial in their behavior. And usually in most stratas, people are just trying desperately to have the quiet life and have their home as their oasis away from the madding crowd. And the bullies bring the madding crowd right to their front door, which of course can create all sorts of problems. So
Well,
next
it's
slide.
interesting that you give them that kind of context, and it's not just there are jerks in your building. You're already explaining some of what's gone into this behavior.
And this is very key, I think, particularly for councils to understand, because when we get into the process as we go along here, you'll see that council cannot just get mad at people who are acting ridiculously. As much as that's the sort of the human response, of course, if somebody's being nasty or violent, even, or confrontational, all these sorts of things, humanly we react to those sorts of things. But counsel has to be the judicial sober second thought in all of this. And if we're not, then there's going to be problems. But if we are, then I hope we can trust that the judicial system, one way or another, will assist us. But as you see, there's a process to follow. So let's look at the
And this
process.
section 135 is of the strata property.
Yes, that's right. So what this is about when something is going wrong in the strata, and either the council hears about it through the grapevine, or someone is specifically providing a complaint saying on Thursday, October the 15th, this happened and so did that and the other, and this is a mess. So 135 says, as you see there, you cannot impose a remedy i.e. a fine, remedying a contravention, or denying use of a rec facility for the contravention of a bylaw, until you've done the next bit, which is the next slide. So there you are. So you have received a complaint about the contravention, given the owner or tenant the particulars. Now that's key. The particulars are the W5, the where, what, when, and why sort of situation. It doesn't matter who provided the complaint, and I'll come to that in a second, but it is very important for counsel, because you're not going to get a nice tidy complaint. You're going to get a rambling email or a rambling phone call saying, well, this happened and that happened and the next thing happened. And it's very important for counsel, with perhaps the help of your property manager, to figure out, is this, if it was true, is this an actual breach of a bylaw? And if so, which bylaw is it a breach of? Because in the particulars, we want to be able to say to our errant owner or resident, on the 15th of October, you breached bylaw such and such by doing thus and so, right? And then when that letter has gone out, and you notice it has to require an option of a written response from the alleged errant owner, or a hearing in front of counsel, or both. So you've got to be very careful to follow this process. And you've also got to give them plenty of time to respond, right? So some stratas will say within 2 weeks, some will within 30 days. The test is always what's reasonable in the circumstances, right? So,
Right.
for example, if you know that this guy who's caused trouble happens to be away on holiday at the moment, it's not good enough that you write your letter and say, please respond within 2 weeks, because you know he doesn't come back for 3 weeks, right? You've got to keep those kind of things in mind. And when we're following this section and following the process, obviously, it's so that the alleged bylaw breacher can understand what the problem is. That's part of natural justice. But more importantly, we're showing the court or the tribunal, if we end up there, that we followed the process properly, because following the process properly is a complete defense to what you might do thereafter. Not following the process will mean that whatever you have done will probably be wiped out automatically. So that's why the process in and of itself is very, very important.
So
Okay.
it seems rigorous, but it's important.
Exactly. Exactly right. And now this is a very key point when we're talking about bullies. You must have received a complaint, as we saw there in section 135, but it need not be in writing. Okay. A lot of stratas misunderstand this section.
Right.
You don't have to have it in writing. The reason we might suggest that if somebody is being intimidated by a bully, that they just phone in their complaint, or they talk to a council member or the PM directly, is because what we have found is bullies will then immediately go to section 35, and they'll say, I want to see all correspondence given to or from the Strata Corporation. I want to see the letter of complaint. And of course, the reason they want to see the letter of complaint is to further bully whoever actually provided the complaint. And so the law does not require a written complaint. So you can quite literally tell the bully, I'm sorry, we have nothing to disclose, because there was no letter. It was an oral complaint, and we're not revealing who provided that material. And I have actually had a number of lawsuits where we have refused to give the letter because of exactly that motive. And if counsel are concerned about that, again, acting reasonably, and we'll talk about duty of care in a little bit, but if counsel think that the person who's demanding that letter just wants it so that they can then go and yell and scream at Sally, because he suspects that Sally downstairs is the one complaining about the noise at 2 a.m. or whatever, then counsel should not disclose it. We can worry about disclosure if it's by court order later, but what we don't want is to not protect innocent members of our community. So
Makes
all the
sense. Makes
particulars,
sense.
all of the details, particularly the specific bylaw that we're saying has been breached, and then wait for a response. Okay, so then next. Yeah, so here we are. So they've got to have this chance for a response in writing and or a hearing. And a hearing means a council meeting. And so ordinarily, if need be, you want to try and arrange an extra council meeting, or if it's within a month, that's probably fine, to just have them come to the council meeting. And what we often do is, because the council has got a long agenda of things to deal with at any given meeting, we just allow that person 5 or 10 or 15 minutes at the beginning of a meeting to come and present their side of the case. Now, it's important, again, for council to understand their role here. Council is not arguing with the, let's call him the respondent. We're simply there sitting as the judge and jury. So we're listening to the other side of the case, if you will. The complainant filed their complaint and said, this is the problem. We've defined it as a matter of law. It was a breach of such and such a bylaw. Now this is the opportunity for the other guy to say, well, that's not true. It's innocent till proven guilty, right? We've got to act reasonably. If the complaint is about noise at 2 o'clock in the morning, and he shows up and says, well, here's my plane ticket. I was in Tahiti the whole time that this complaint is alleged, so it can't possibly be me. Obviously, council's got to do a little bit more thinking. So at a hearing, council's not really needing to do any talking. You can do clarification questions, those kind of things, but you're not going to argue. You're not going to back and forth with this chap. You just want to get his side of the story. And then when he's gone, then council can deliberate and say, okay, here's the complaint, here's the evidence we have here, here's the defense and the evidence we have there. What are we going to do about it? So it's very much that judicial role that council's got to take care of.
I can see that being difficult in certain cases. I mean, I assume in some communities it's sometimes a member of Strata Council that is the complainant, and how do they handle that?
Yes, exactly right. In fact, that often happens, Tom, because it's often council members who are much more aware of what the bylaws actually say. And so in those cases, it's often best that um, complaining council member recuse themselves from the hearing and any deliberation. Again, not because they're necessarily going to be, you know, uneven-handed or anything like that. But again, we're dealing with process and perception here, right? And as with so many things, perception is reality. And if we're trying to deal with this so that both we deal with this and it's done, and we're preventing other things in the future, it's best to try and preempt all the possible complaints that our respondent is going to bring up. He's going to say, well, the hearing wasn't fair because I found out this guy was the guy who complained and he was there sitting in judgment on me, blah, 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 right? May or may not be true at all in actual reality, but the perception might be enough for a judge or a tribunal to start doubting the process.
And worse, it has more emotional involvement, I think, at that point. And
Oh yes, and this is very important. And when we come to the duty of care, that will come up again. Council has got to be able to set aside personal feelings or fears, particularly when we're talking about bullies. It's easy to react in fear, but council must be methodical, must be careful, must react properly. And so that includes, as you'll see later, that you've got to react. You can't pretend like the complaint's not there. You can't pretend like there might be some explanation to it that needs further investigation. You can't just push it under the carpet, otherwise you may be creating another problem. So all the emotions that will naturally bubble up in council members, they've got to be able to set it aside and say, okay, we've got to act in the best interests of all owners here. We've got to be the judge. We've got to do it carefully and properly. And as you see here on this slide, the options are limited as to what can be done. We can dismiss the complaint. If the guy was in Tahiti, well, then obviously it wasn't him creating the noise at 2 in the morning. So that's the end of that one. Or it might be a fine. And the general rule is under the regulations, we're allowed to fine up to $200 per incident, unless it's a continuing contravention, something like an illegal Airbnb or an illegal pet or something like that that goes on continuously. That would be $200, up to $200 every 7 days until the matter is resolved. And we'll talk about that more in a minute. The costs of remedying a contravention under Section 133 is actually a very powerful tool, because if there's evidence that something has been done, let's say an alteration without approval, and they won't fix it, then the strata can go in, as long as it's followed the proper process, and go and fix that alteration, put it back the way it was, and then send the bill to the owner. So that could be many thousands of dollars under that provision. Or finally, if it's a specific breach in relation to a recreational facility, then they can turn off that owner or resident's fob for a time, because they're saying, well, you were running around the swimming pool and you had a glass bottle in your hand, and that's absolutely not allowed. So we're going to ban you for 2 weeks until you calm down, and then we'll try again. So not a lot of options, but as I say, some of them are very powerful. And then in a minute, we'll talk about what else has to happen if people don't pay attention to the remedies that we put on them.
Right. So with that denying access to facilities, you're talking here in weeks or a month. You can't be unreasonable and ban someone for life, or
Exactly right. I mean, I think the presumption would be, if it's a minor issue, let's say it's just running in the pool deck, but they don't have the glass bottle, which obviously would be a bigger risk. But if they keep running, I think we could legitimately say, okay, well, we're going to ban you for a day, and we're going to ban you for a week, and now we're going to ban you for a month if they keep doing it. Right. So again, think about explaining this to a judge. That's the way you've got to have it in your head. Why would I be increasing the punishment? Well, because they didn't pay attention the first time. That's a completely reasonable thing. We do that in the law all the time. If you keep doing the same thing wrong, we're going to punish you more. But we don't want to start, at $1,000 fine and 6 months penalty.
right? Yes, not being reasonable, and of course, how likely are they to listen?
Yes. Well, okay. So that's part of our topic today, isn't it? Of course, the bully types, or the schizophrenic types, or the Alzheimer types, or the drug addict types, or many other sorts of people are not going to pay attention, because they will just assume that the law doesn't actually apply to them. And so this case I've mentioned here is the concern that we have. If somebody's not paying attention to us, we can do repeat fines or repeat contraventions under the rec rules or what have you. But after a while, you have got to say, okay, we're here to enforce the bylaws. That's what Section 26 of the Strata Property Act says. So we've got to enforce them. We can't just keep fining or keep banning them or keep doing whatever we're doing if they don't pay any attention to us. And so what the Wilson case says, and I think there's a quote, is there, Tom, next one? Yes. So here, let me just read this because it's very important. The key factor in this case is the Strata Corporation has an obligation to enforce its bylaws when they are breached. You see that? Obligation under Section 26. Council must enforce the bylaws. Accumulating fines in the amount of $10,000 is a form of punishment, not an enforcement of its bylaws, and is unreasonable. And a judge is always going to ask themselves, what would be reasonable in this particular situation? The Strata Council should have taken steps to enforce the bylaw. Until this petition was filed, the Strata Council did not seek to enforce Bylaw 136 by obtaining an injunction. That's an order from the court that says, stop doing what you're doing, right? If you're breaking the bylaws, you must stop. And if you don't get that kind of order, the court's saying you're not doing this properly. That failure has directly affected the number of months in which the Strata lot was rented in contravention of the bylaw. As a result, the fines which could justifiably been levied against the petitioner has also been affected. I am satisfied that an order should be granted cancelling the accumulated fines in the amount of $10,000 levied against the petitioners, having regard to the history of this matter. So you
Wow.
notice that the judge is not saying there wasn't a problem, and you could have dealt with it differently and I would have been on your side. They're saying it's because you weren't taking care of it properly. That's now why I'm again you. And they lost all the fines, and therefore they were basically back to square one with obviously an illegal rental in that particular situation. So this is where we have to say what's reasonable for us. How many months or weeks of fines where somebody's ignoring us can we get away with before we have to file further legal proceedings? And that's, how long is a piece of string kind of question.
It is,
But I
but I mean, 10 or 12 weeks must be a reasonable
oh,
time to
a-
escalate it now.
absolutely, absolutely. And I think what also would be good, Tom, in these kind of situations is that if there's two or three repeats, that the letters going out again saying, okay, there's another fine, is please be advised, if this continues, if you do not pay attention to us, we will be filing proceedings in the CRT or in the Supreme Court to seek an injunction against you. Please see the Wilson case, right? And so we can
Right.
give them proper notice and say, look, we're not mucking around here. We have to enforce the bylaws. You are breaching the bylaws. We've tried to make you stop with persuasion and financial persuasion, and you're not stopping. So our only next step is to go to court or to the CRT. Now, the CRT will take forever, but they are allowed to enforce fines. So what you want to do in those circumstances, if you have to go to the CRT, is to say to your delinquent owner or resident, we will continue to fine while the CRT adjudicates this matter, so that when you come to actually file your argument with the CRT, which may well be at this point like a year after you file the initial claim, you could say, well, he has continued to breach the bylaws. And so we do actually have $10,000 worth of fines. But when we filed this, there was only $1,000 or what have you. But he has continued to breach. So we're claiming the full amount, but we are following the Wilson case. We started this a long time ago. It's not our fault that you CRT takes so long to make these decisions. So please provide us an order for the full amount. And then if you get a judgment for $10,000, let's say, then you can start using that as an enforcement leverage to get your bully out. Because if they're not going to write a check, well, then one of the things we can do under the Court Order Enforcement Act is force a sale of their unit. It takes longer than a lien process, but it nonetheless means the unit is sold, and therefore you get rid of your bully as well because they have to leave the building.
I think some people might be thinking, when do they go CRT? When do they try going to the courts?
Right. Well, if it was up to me, I would do my level best to avoid the CRT. Both for one, the delay in time wise, and second of all, the CRT does not need to follow its own precedent. So it can say yes today and no tomorrow to exactly the same set of facts. Whereas the courts are much more consistent because they have to follow precedent. So if you can put it into court, yes, it's a bit more of an involved process. Yes, it's probably going to cost more. You're going to have to get a lawyer involved, but you will also have the right to costs under the proceedings. So a certain proportion of the legal fees will have to be paid by your delinquent owner or resident. So what you've got to be able to do is look at the CRT Act and see if you can exclude yourself from their jurisdiction. I think that's the presumption is you start with them, but if there are other matters involved that would take it out of the CRT's jurisdiction, then you can go to court. So CRT, cheaper, much longer process. Court, much more expensive, but with which a bigger bang for your buck probably in the long run.
Understood. So council's not supposed to be perfect. They have a reasonable standard of care that I'm reading here on this page.
That's exactly right. And it's very important for councils to remember that, because I think some people get on council and they start reading about duties of care and legal liability and all the rest of it, and they freak out thinking, oh my goodness, if I make any mistakes, I'm going to be in trouble with the law. That is not the case at all. And the courts have been very, very careful to say exactly what you just said, Tom, is they don't need to be perfect. These are volunteers. We understand that if your day job is a plumber, you're not going to understand accounting. And if your day job is a nurse, you're not going to have much insight into the law. So that's why the courts have always said, if counsel needs expert help, whether it's a plumber or an accountant or whatever it is, that is an appropriately reasonable thing for a counsel to do, to get the help it needs, so that if it needs to make a choice, if it needs to investigate something, if it needs to fix something, it's not a bunch of nurses and plumbers who are trying to do jobs of other professionals. So keep that in mind. A mistake as well is not negligence. Okay. Negligence is when you know you should do something and you do another intentionally. You're reckless with the situation, as opposed to you made an innocent mistake. Okay, so take some comfort from that. That first of all, the judges are not going to expect you to be um, perfect in any way. However, this section is absolutely key for all council members to memorize, so that you know what you're doing when you're in a hearing, when you're making a decision on council, when you've got financial decisions to make on behalf of all the owners. So let me just read it. In exercising the powers and performing the duties of the Strata Corporation, each council member must act honestly and in good faith with a view to the best interests of the Strata Corporation, and exercise the care, diligence, and skill of a reasonably prudent person in comparable circumstances. So that last bit you see is, if I'm a plumber and we've got an accounting problem, um, it's not prudent for a plumber to pull out their pencil and start figuring out the accounting. Whereas it is prudent to call the accountant and say, hey, we've got this problem with our math, right? So that's where that is. Good faith talks about the idea of a proper motive, like your motivation is not impure. You're not making a decision on council because it will make money for you personally, or it will be good for you. You'll get your kitchen refurbished and everyone else will pay for it, and no one else gets their kitchen refurbished, right? That's duplicitous, to say the least. And let me be clear about the first part there. It talks about powers and duties. Okay, these are very specific things in law. A power is something you can do, but you don't have to do. So you're probably very aware of the phrase a power of attorney, right? Which is somebody who can act on someone else's behalf, but they don't have to, right? So that they don't have to do anything. There's no compulsion in a power, right? So the strata in the act, there's lots of things where it say the strata may do this or it may do that. That's a power. When it's a duty, that's where the act says the strata must do this. And that's when there's no choice. So a big one, for example, is the duty to repair and maintain, right? Section 72 of the Strata Property Act. You don't have a choice there. Same as you don't have a choice about the enforcing the bylaws. That is a duty you have. Whereas, other things like passing other bylaws. The Strata Corporation may pass other bylaws. It may amend its bylaws. It doesn't have to, right? So be very aware, if you're on council, what things do you have to do? And then what things do you have discretion over? And then what things can council do versus what things do we have to go to the owners to get permission to do?
I
That's
like
key.
that. We talk about strata education a fair bit. There's been a lot of conversation around doing a bit better with education. Those are some pretty fundamental points that I think every strata council member should know. Thanks.
Yes, no, and we preach very much a preventative law model. Like, we would rather that a council come to us and say, look, we'd like to meet with you because we've got this problem person in our building, or we've got this issue with our bylaw, or we'd like to do something about this, and spend a little time and money in advance of it becoming a problem to fix it or set up a situation where it's not going to be a problem, versus waiting for it to become a problem and then calling in the lawyers like the fire department after the fire has started. Well, I can tell you quite literally that's hundreds of thousands of dollars difference in legal fees, of trying to deal with something proactively rather than reactively. and we'll get into some of that later. But I urge councils, if there's something smoldering, well, where there's smoke, there's fire. Let's get the fire department lawyer in there right away. Help figure out what's going on. Deal with it proactively so that it doesn't become the $300,000 litigation file.
An ounce of prevention can go a long way.
And that's for sure.
And this is hard. You've got it right on the screen.
Yes, no, because I think naturally none of us want to deal with bullies. None of us want to have to confront someone who is aggressive or angry, or I mean, I've got one right now. The person is violent. These are very intimidating factors. But again, council has to set all that aside. And if need be, of course, you can make the lawyer the bad guy and have the lawyer confront somebody. That's a perfectly reasonable tactic. But you can't, as I say before, you can't sweep these things under the carpet, because the bully's not going away, and all the people intimidated in your building are going to be more and more scared. And that's just a situation waiting for a disaster to happen. So
we're going to park the bully for a moment and hit with a pretty shocking statistic about the percentage of Canadians that are hoarders.
yes, I know. And when I first heard this, I was shocked as well, like you obviously are, Tom. It's
Yeah.
so you've got an apartment or a condo of 100 units. You might well have 6 hoarders within that building. Um, that is a very, very big issue on so many fronts. Obviously, it can be a fire risk, it can be a health risk, it's certainly a breach of the bylaws. And so again, this is one of those problems that once council hears about it, it's not an issue. You must deal with it head on. So next slide.
It is a shocking number, isn't it? Oh, this
Oh,
looks fine. This is a nice little bedroom.
so this is for those of you who haven't seen this before. Often the fire department will use this clutter image chart, and it was actually created by a professor in Philadelphia. And you can go online and find it yourself. It's got multiple rooms where he shows what it looks like at 1 through 9 steps of clutter, he calls it, like of hoarding.
Okay,
And
five's looking pretty bad.
yeah, that's at least the teenager's bedroom, right? I mean, that's definitely not good. And then this is when you're talking about very, very serious fire risk, risk to life of the hoarder themselves, risk to life of the other people in the building. Highly likely that we're going to be dealing with vermin, at the very least, cockroaches and silverfish, if not rats and mice, and all those kind of things as well. And what we have seen is sometimes if you can provoke your fire marshal in your district to come and have a look at a situation, they can provide an order of the fire marshal that the clutter be reduced from 8 or 9 down to 4 or 5 or 3 or what have you. And I had a case once where the fire marshal did that, and I think it was Vancouver. It may have been Burnaby. I think it was Vancouver. And so the hoarder didn't pay any attention to it. And so we sued the hoarder in Supreme Court. We said there is an order here from the fire marshal requiring this to be done. So we're seeking an injunction, judge, to require the hoarder to do it, or that the strata be entitled to do it under Section 133, right? Um, and that we will then do the work, but the owner will then pay for it. Now, what was clever in that situation was because it was per an order of a municipal authority, that becomes a lienable amount. So you can go do the cleanup, send the bill, and if they don't pay it, you can lien the property and sell it. And so there, again, your hoarder is gone because you've sold their unit. And I mean, I had a case once where we had that kind of order, and this is a long time ago, probably 15 years ago now that I think of it. The cleanup bill for the hoarder was $135,000 for a 1 bedroom condo. And so when we came time to pay the bill, she basically moved out and we sold the whole thing. And there was at that time virtually no equity left after the bill was paid. So
That
it can
is
be very
shocking.
draconian. Yes, it can be very harsh. Um, but again, council's got to act reasonably. We can't just sort of come in all guns blazing right from the get-go and do that as our first step. We've got to understand the psychology going on here. And the next slide set out a little bit of at least one theory that there is about what's going on when somebody's hoarding. Um, so here's the idea. Like a hoarder has experienced some sort of trauma in their prior life. They've had a loss, which just creates an enormous deficit in their mental space, like a divorce or a death or something of that nature. And then they retreat, as often many of us do. If you have a problem, you retreat from society. But then a hoarder, what they do is they, instead of going back into society, back to their family, back to their friends, they separate themselves from human contact, and instead they put that emotional energy that we put into our family and friends into the stuff that they've got in their property. And so
Interesting.
what ends up, this is the theory, is that then the stuff becomes friends. And so the more stuff you have, the more friends you have, right? So it's not that the stuff is important to them. It's like, it's just the volume of stuff gives them that emotional comfort that friends or family would otherwise provide. So again, I say this because it's the theory that makes sense to me, at least in the folks that I've seen, but it gives you a little bit of insight into what we might be going on, so that when we as council are dealing with this situation, we have to enforce the bylaws. And I think the next slide might be the bylaw. We've got to be reasonable, and we've got to deal with the specifics of the situation, right? So obviously, look, their standard bylaw 2, this owner is not repairing and maintaining their strata lot, right? And if we're starting to see the smell, the cockroaches, the
Right.
mice escape from their unit into other people's units, well, then obviously they're creating a nuisance as well.
I was
So
going to
we,
say, if you didn't have a
yeah.
view through the window to see the stuff piled high, it takes a smell or a pest to
Absolutely
identify it.
right. And often, Tom, these sort of folks, even if they're on a ground floor unit, they will put up curtains and what have you so that they know no one can see in. Because there's often a great deal of shame goes along with hoarding. They know that they're doing something foolish. They just can't get out of it, like because
Right.
they're sort of so blinkered emotionally. So I was going to say that therefore council must, it's got a duty to enforce the bylaw. Here's this bylaw, or there's bylaw 3 about nuisance and causing a hazard for other people. We've got to follow 135, as we were mentioning earlier. But so that's the law, right? What we're required to do. But there's also part of the law, if you will. We have a thing in the common law jurisdictions called equity. And equity is the question about what is fair in any given situation, right? So council has to be enforcing the law. We're not allowed to pretend like this not happening and it's not going to come to an end some point, but we're also expected to be equitable. What is the fair way to deal with somebody in that situation? So it may be that there's council meetings,
Right.
that there's visitation to the unit. Of course, they might not let you in. There needs to be a gentle process of getting them to the point where we're saying, well, look, we're sorry that you can't just deal with this yourself, but we're going to give you a month, 3 months, 6 months to get this sorted out by yourself. And please ask for help. Here's some people who might be willing to help you. Here's contact for, the garbage people, all that kind of thing. Try and help them, but you've got to create a deadline because they're going to walk right up to that deadline before they do anything. And then, then there's going to be a problem. But if you can create that sort of process first, when you do end up in front of a judge seeking the injunction, seeking the sale of the unit, whatever it might be is your ultimate remedy, the judge is again going to see that you have acted reasonably, acted fairly through the whole process. So
Right.
that's very key. Now, I just wanted to mention this because this comes up a lot with hoarders, but with many, many people too, about the strata getting into units to investigate what's going on. All right. And you notice here, this is standard bylaw 7, which many people adjust accordingly. But you notice it says an owner, tenant, occupant, or visitor must allow a person authorized by the strata corporation to enter the strata lot. All right. So do not take no for an answer. If under this bylaw you give proper notice as the strata corporation, and remember there's a process in terms of confirming deemed delivery under section 61, I think it is. You've got to wait 3 or 4 days until it's deemed delivered, um, and then you've got the 48 hours notice period after that. But after that, and I'll get into trouble for this, but I'm firmly of the opinion that you ask for forgiveness, not permission. And you tell them you're coming in, and if need be, we're going to call a locksmith to change the locks to get in, and get in and have a look. Because, particularly in a hoarding situation or other circumstances we've had to deal with where there was criminal activity going on, for example, um, council has to act in the best interests of all the other owners, right? And so we can't let this go on. And to me, there is no right to privacy in these circumstances because we have a statutory authority that says we're coming in. And so, as a matter of legal theory, the
Right.
owner doesn't have the right to say no. And
And,
here's
and
a
you've
section.
given them notice and you've told them when, and they have adequate time to prepare for this visit.
Exactly. You've got fair process. We're not just barging in at 2 o'clock in the morning by any means, unless the place is on fire. Of course, we'll certainly do that. But yes, that's exactly the point. Is the owner does not own a strata lot with what the law would call exclusive possession. Like day to day, they do, but this, unlike a single family home, there's this exception in the act that says, no, because you're a part of a community, the strata corporation has an absolute right to come in to your property if they need to. And of course, again, we have to act reasonably. We're not coming in just to have a look at their drapes and see what color carpet they've got. But if we think there's problems, or if there's an emergency, there's fire or there's water coming out from under the door or somebody's screaming their lungs out in the unit, break the door down first and ask questions later, is definitely my advice. And you see here, Section 77 of the Act, if there's common property that can only be accessed in that unit, like let's say the balcony's got problems, or there is a fire suppression system, or a hardwired smoke detector system, something like that, or the strata. Another thing I can think of, the strata comes into every unit to service a fireplace or something like that, something where the strata has an obligation within the strata. Again, the owner must provide access so that strata can deal with that common property as well.
Excellent.
So don't be intimidated.
Excellent.
Here we are then. So here's a bit of a summary. Use the clutter scale when you go to visit. How bad is it actually, right? See if your fire marshal will help. Sometimes they will, sometimes they won't. It's a bit of hit and miss. Um, Consider intervention of the PGT or social workers. The PGT is the public guardian and trustee, and these are government workers who will intervene if they think someone is at risk, either
Right.
financially or physically or otherwise. And they will work often with social workers or medical folks. If there's, an Alzheimer patient, for example, who's also a hoarder, they may say, "Okay, time for you to go into care," and they'll take care of it. Next of kin. This is one we just recently dealt with. Actually, we had an old lady in a building, and she had a guy come live with her, and the strata was very suspicious that this was a guy just taking advantage of her, because he wasn't, as far as they knew, next of kin. He was just a guy who managed to worm his way into the building, and they think he was stealing money from this old lady, and she was clearly starting to lose her marbles. Um, anyway, we didn't know anybody who was next of kin. So, but over the course of 2 or 3 weeks, working with the PGT and other with people, we finally found out there was family. There was quite a lot of family, in fact. And so they quickly intervened. They took over from the Strata Corporation. They were able to get grandma into care, and we were able to throw out the usurper in short order. So these things often, the psychological stuff. Um, Stratas are not psychiatric nurses. We're not supposed to be dealing with this stuff, but often in our society, we're finding people being left in stratas. It's the psychiatric patient, it's the drug addict son, it's the grandma who's got Alzheimer's. They're getting dumped into stratas and just left. And of course, we're not really equipped to deal with this, and we have to deal with it as a bylaw breach rather than a mental illness or what have you. So if you can get these sorts of resources in as around as well, that will also add to, if you need to go and get some sort of draconian order, a judge will see that you have been equitable in the process, you've been reasonable, you've been trying to deal with the very difficult issue of mental illness or what have you. So
Yeah,
there we
because
are.
you'd always hope that the next of kin would be a resource to help in the matter, not the source of the problem.
That's
But
exactly right. But we've seen both, unfortunately. And it's really frustrating when you've got people who they're in denial, if you will. Our son doesn't have a drug problem. No, he's not a psychiatric case. Grandma's fine. What are you talking about? Just because she's wandering around with a machete at 2 o'clock in the morning, she's fine. What are you talking about, right? All of that stuff I've dealt with, and so we need to be legal, we need to follow the law, we need to follow our duties, and we need to be, as best we can, those equitable brokers to get the other resources in, because it cannot stay. The status quo cannot stay. It's got to change, and that's where sometimes councils are in a tough spot.
and
All right.
eventually it comes to filing a lawsuit.
Well, exactly, and that's sort of a last case resort, of course. As I said earlier, we're trying to be preventative in what we're doing, but it's not easy. So if a strata is getting stuck, again, the reasonable thing for a strata to do is to get help. I've dealt with a lot of this stuff, so give me a call, or get the PGT involved, get the police involved, see what the social workers might be saying, those kind of things, so that the council doesn't feel like it has to carry it all. And again, they get worried that something bad is going to happen. There's going to be a fire because we can't get the hoarder out and all the rest of it. Again, if you're showing that you're taking reasonable steps and getting help, um, then you're not going to be accused of being negligent in your role. Because what else could you do? You're not a
What else could you
psychiatric
do?
nurse. You don't
Absolutely.
know, right?
Yeah.
So
But if you do nothing, then eventually you are putting yourself in a breach of duty.
well, exactly. No, exactly. Because what you're doing there, as it says here, is you're failing to enforce your bylaws and you're breaching that section 31 duty, right? The duty of care. You must act in the best interests of all owners. So perhaps you use that question when you're dealing with difficult things is, well, what would it look like if it was for the benefit of the majority? Right? And sometimes that is the case, and the courts have appreciated that. Sometimes the rights of the majority have to outweigh the rights of the minority, and you need to do something. This case that I mentioned here, that just came down just a couple of weeks ago, says that quite clearly, that if council members are going to ignore their duties or, in fact, act in bad faith, then they may well be personally liable. And so that's quite a change in law, because before that, um, it was essentially only if there was a conflict of interest that the courts were saying that councils could be sued personally. But what this case appears to say is that if council does something or doesn't do something that it should, and that causes a loss for a particular owner or owners, those owners might be able to take action against the council members. So if you need incentive to actually do something, that might be it.
And you're touching on this subject of good faith and bad faith. Can you elaborate a bit more on what that entails?
Yes, certainly, certainly. So as I was saying earlier, good faith is the idea that you do what you do without any impaired motive. So you have no impure motive. Your intention is simply to act in the best interests of the owners. And in my mind, that means you've thought it through and you can give some rational reasons for why you think this is in the best interests of all the owners. To give you a silly example, council decided that we were going to buy insurance for the building. Well, why is that in the best interests of all owners? Well, first of all, the Act says we have to do it. And second of all, we don't want anybody to suffer a loss. Third of all, the Strata Property Act is consumer protection legislation. So how are we protecting our owners' equity if we don't have insurance in case we have a massive fire or what have you, right? So there, very easily, I've articulated why council should say, let's make sure we have plenty of insurance all the time, right? Obviously, it gets harder when it's bylaw breaches or there's mixed evidence in a hearing where you don't know whether something bad happened or not. Now you've really got to put your thinking cap on. Um, but that's the idea of good faith. You're just trying to do what's right for everybody else. Bad faith is the opposite. I've got ulterior motives. I'm doing what I'm doing for my benefit or for my family's benefit or for my friend's benefit. I'm ignoring a bylaw breach of Joe because Joe's a good guy and he's my friend. So I'm not going to worry about that as a council member. That's actually bad faith, right? Because you're not doing your duty. And this
And
case,
this
sorry,
case, yeah.
yeah, the Monn case, the judge ultimately decided not to find damages against the council members. But interestingly, she warned them. She said, but if you keep doing what you're doing, I invite the petitioner to come back and let me know because I might well then find damages against you. Because in that case, what the allegations were that was the council were treating one set of owners quite differently from another set. So it was literally the people with balconies and the people without balconies. And they didn't want to have to pay for all the stuff to do with balconies because most people didn't have a balcony. And they did lots of things in that sense where they were not treating everybody the same. And the court said, can't do it.
It's interesting. I mean, I've seen things with types before, a subsection of strata that I hadn't really been aware of, where there are types where balcony units got different treatment than the type that did not.
Yes. Oh, and it can be, right? It certainly can be if that's been a thought that's gone into the bylaws and everybody's approved it, right?
Yeah.
But in this particular case, there was a long history of those and such of those, if you see what I mean.
Oh boy.
And the evidence was that all the people with balconies were clearly very affluent, and so they could afford more than everybody else.
Not the same. Not the same as a type.
No,
No.
no, exactly. Not exactly. Yes. Okay, so here, just wrapping up these ideas that I was mentioning. Hoarding is not a human right. Okay. The effects of hoarding are an actionable nuisance because they affect the quiet enjoyment of everybody else, right? They are a physical danger to the hoarder and to everyone in the building. Um, they are huge fire risk. They're a very significant disease risk. And I'll mention too, by the way, this is where the worlds of strata and rental collide. If the hoarder is a tenant, that's an automatic breach of the tenancy as well. And there's a section of the Residential Tenancy Act that says the tenant must keep the, the rental unit clean and sanitary. And obviously, a hoarder is clearly in breach of that. But you might have situations where the landlord is mum and dad or a far flung family member who doesn't want to evict the person who they don't want to pay any attention to because they're a problem. And then in those circumstances, it may be that the strata has to step into the shoes of the landlord under Section 138 of the Strata Property Act, and it's deemed the landlord, and then it can go to the the RTB, sorry, to um, file for an eviction. So
Wow.
all sorts of nuances around these kind of things.
Yeah,
Uh,
that's a whole additional area of complexity.
oh yes, and it continues to get more complex. So here's our proactive solutions, as we've been saying, trying to think ahead and do things to stop the problems before they can arise. So I'll just run through these really quickly. Educate your community. At every meeting you have an opportunity to explain a bylaw or explain how things work. Show them the strata plan. Most people buy a strata, they have no clue what they've actually bought. So explain to them, well, this is your unit, but the balcony is limited common property, so it's not actually yours. You just get to use it. Those kind of things. Patience, very much so. Being reasonable, being considerate, acting equitably. That reasonableness, the do unto you as you would have done unto you idea, very, very strong. That's very much the idea of what's in the best interests of all owners. Because another way to say that is, if we did this to everybody, or if we allowed everybody in the building to do that, would everybody be happy with it? Right. And this is where good faith, bad faith comes in again. Because if your friend says to me, hey, Phil, I want to put a 10-foot barbecue on my 11-foot balcony. Are you okay with that? And I say, oh, sure, whatever. And then everybody does it.
Yeah.
Now your building doesn't look like a building anymore. It looks like a hardware store selling barbecues, right? So you've got to think those things through to be reasonable. Act quickly. Again, their equity has a thing in it called latches, which is the idea that if you sit on your rights, the court might say, oh, well, you've acquiesced to the breach, and therefore we're not going to enforce that particular bylaw. So this is where you can't shove it under the carpet. You've got to deal with it forthrightly. Otherwise, what if a judge says, oh, well, but it looks to me like you like hoarders because you haven't done anything for 6 years. I'm not going to worry about it. Right. So that's important. And then, as we said, follow Section 135 very, very carefully.
Getting the sense that the emotional intelligence is very important as a
It
strategy.
certainly is. It certainly is. And that's often, it comes out often in the small stratas where there's only half a dozen owners. And of course, everything becomes personal at that point. When you've got 500 owners, you can get lost in the crowd and it's less intense that way. But when it's Jim and Mary and they're at each other every council meeting, then it can be very difficult and you quickly lose the wood for the trees emotionally. And that's not going to help if you're trying to get the court's assistance down the road. So very quickly, use as many objective measures as you can to quantify a complaint. Like, how loud is the loud? How stinky is the stink? What time are we talking about? Does this really matter, right? You've got to get things out of a de minimis range, a minor range, because nuisance is a significant interference with the quiet enjoyment of property. So somebody dropping a bowling ball at 2 o'clock in the afternoon because they were cleaning it and they did it, not that big of a deal. If they're actually bowling in their unit at 2 o'clock in the morning, well, that's much more likely to be called a nuisance, right? So let's be very objective about this because the judge is going to do that. They're going to say, okay, in any given building, if this was happening, would it be a breach of the bylaws? Try and be consistent as you can because human nature. If you let one person off, the next person is going to say, well, but you let him off. Right? So make sure you know why you let them off so that you can distinguish the one case from the other. Be proactive about good neighbors things. I've seen stratas, interestingly, who have things like a family day and they order in the bouncy castle and they have a barbecue and everybody gets to meet one another. I can't tell you how helpful that can be because it's much, much harder to start accusing people of this, that, and the other thing when you actually know their name and you know a little bit about them and you've seen their kids and you've met their grandkids and what have you, right? It makes a big difference psychologically in a building to try and, again, proactively avoid the problems. So next one, thank you.
Yeah, absolutely. We talk a lot about building community and building those relationships, and it's very easy to complain about the noisy running of children. But if you actually know them and they're really sweet, and then you are slightly more understanding when you hear them, thumping around upstairs at 4 in the afternoon.
Exactly, because kids will be kids, right? I mean, we can't change that. And so, where is the accommodation that lets live and let live, right? That's very important. Um, on this slide, I'll just mention the financial pressure thing. Often we have found, particularly with bullies who are not interested in being social, they're not going to come and play on the bouncy castle. Their intention, whether it's psychologically rooted or not, is to be incredibly antisocial. We have often found the only way to actually push any change is through financial pressure. So if that needs to be, well, then that needs to be. In the context of what we've been talking about, um, as I say, the status quo cannot continue. If you've got somebody who's dangerous or what have you, they need to go. And so often financial pressure is the way to do it.
And finally, documenting. You need to make sure that you are catering to the eventual ultimate audience of all of your work, and that could be a judge.
Absolutely right, and even along the way, um, because I've seen this before, where something has gone on, there's been a big blow up about somebody getting accused of a breach of the bylaw, and then at the AGM, there's 10 owners coming after council, telling them they're a bunch of crooks and all the rest of it. That's when council needs to be able to show those objective measures and say, well, here's what happened, and here's the letter we sent, and here's the evidence we had, and here's maybe what your friend who's mad at us is not telling you about the situation, or what he did and that he didn't mention this mistake, or what have you, so that council can defend itself, right? Again, obviously at an AGM, you may or may not be up for re-election, but a good council is always going to be able to run on its record. If they want to be re-elected, it's because they're doing their level best to act in the best interests of all owners. They're getting the help when they need it. They're trying to be reasonable. They're following the law, but they're being equitable. They're acting in everyone's best interest. And really, at some point, a judge has to say a council like that is simply above reproach, because what else could they possibly have done? So
And
I hope
ultimately,
that was
that's what
helpful.
we all want, right, Phil? We want a happy community where people do get along and accommodate one another, because we are all different. And, we ultimately need to get to a place where that can be done peacefully. And sometimes that requires action.
Oh, absolutely right. And again, just to say, it's worth the effort, because the alternative is incredibly expensive. And I mean, some of my files go on literally for decades, right? So if you want to have me in your life for 10 years, feel free. Otherwise, I suggest, think preventatively.
If you want to get Phil in your life, whether it be short term or long term, citadellawyers.ca. I'm going to bring that up on screen. Please use that QR code or go to citadellawyers.ca. So thank you for that, Phil. And thank you very much for joining me today. We don't have much time left. We've already run the full hour, but I did want to touch before we left it on some of the other issues that are affecting strata communities more with the change in rental legislation over the last couple of years. Can you tell us what the impact has been on strata and how you can help?
Yes, certainly. I mean, when it first came in, there was a lot of stratas that immediately phoned us and said, okay, we want to put in 55 plus bylaws so that we're not getting rentals in our building. There was a lot of fear, quite honestly, that tenants are not like owners and what have you. And of course, there are some that are
Yeah.
not ideal. But mostly, fortunately, it has not been a big tsunami of inappropriate tendencies. Not a lot of people necessarily took advantage of those situations. Some people have more because essentially the provincial government has outlawed a lot of Airbnbs. So they've just moved to ordinary rentals in those situations. And those, yes, I mean, stuff under the Residential Tenancy Act, it is what it is. If you're a landlord, you have to do your level best to pick your tenants incredibly carefully. The market is softening at the minute. So it's a little bit harder for landlords to be as picky as they used to be. But one property manager who happens to be my property manager for my home, he told me his job is 99.99% choosing the right tenant, right? So I think that probably is true. That yes, it's going to probably always increase over the course of time. We're going to have more rentals in our condos than before. But if you're careful as a landlord, if you've got a good property manager, you can at least minimize the risks that attach to that.
And when should a strata council call you when there's a problematic tenant and they can't seem to get action from the landlord?
Well, again, sooner rather than later, right? Because I mean, my immediate assumption will be that my first job might be to write to the landlord themselves, because obviously, if we can get them dealing with it, that's less time and hassle and money for the landlord. And the residential tenancy branch are very suspicious of strata corporations. They're not sure that they appreciate the law as it stands. So it's an easier fight for the landlord than it is for us. But again, obviously, if you get to that point where you have a tenant who simply will not keep within the lines of the Stratas bylaws, well, we have no choice. We have to move for an eviction because we can't let it lie.
Phil, thank you for that. I could go much further on the unintended consequences of legislative changes like that. And I feel that there's also a big financial impact when it comes to having investor owners as opposed to occupant
Oh,
owners.
sure. Mm-hmm.
But that's a topic for another conversation. Next week, I will be joined by Grant Purcell to discuss the transition from squeegees to drones, cost-effective innovation facilities. So a slightly lighter topic than this one. But Phil, thank you so much for your time and your expertise in this.
All right.
I hope everyone does reach out to you on their issues on this matter, and we'll speak again soon.
Thank you so much. Take care, everyone.